Daniel?
Yes, how are you?
Good. This is Roger Christensen. I've got Commissioner Reed and Commissioner Walker here, and the assessor and some staff from the assessor's office. So how can we help you?
Okay, well, let me see, can you guys hear me okay? Let me turn my tractor off here. Okay. Just clearing some snow. We got a little bit of snow down here in Utah. So what I needed from the commissioners, and I was up there last week and went to the assessor's office. What had happened is we had purchased about, I think there was 20 lots up on Panorama Hills, and these lots are zoned residential agriculture, and they have been platted since 1972. And these, in fact, can I turn my, you guys want me to turn my camera on, or?
Oh, yeah, if you want to.
Okay. Yeah. So anyway, these lots were platted in 1972, and this year there was a notice that was sent out. I purchased these lots with my father-in-law, who lives in Idaho Falls. I live down here in Utah, and we didn't receive the notice. He must have got it in the mail, but he didn't, I guess, notice it or take notice of it. And the assessor had assessed the lots as if they were building lots, which they aren't, because technically you can't get a building lot until, at least on these lots, Austin will not let us get a building permit until there's a paved road. So we only had, there was only 4 lots that could have a building lot, and one of them we'd already sold. And so between my father-in-law and myself, there's only 2 lots that technically can be built on. And so I don't have an issue with the assessor's office changing the value of those 2 lots. But what I had an issue with is they went ahead and changed the value of all the remainder lots, and it raised our taxes by close to 700%. So they valued those lots that couldn't have a building permit at about 8,000 to 9,000. They changed that to 51,000. And so I went and talked to the assessor's office last week and explained this to them about this issue. And he says, well, I need something either from the commissioners to make a change to do a tax cancellation, or I need something from Austin saying that these lots are not valued at that. So we need to change that. And so I did. I went and talked into Mr. Walker, who I think is there. I can't quite tell.
Yes.
Who's all there. But anyway, I spoke with him, and then I went over and spoke with Austin, and he sent a letter, which I think I left there with Natalie, I believe. And the letter just simply states, let me pull it up here. It just states, it says the following lots owned by P&S Development are not currently buildable because of all the improvements have not been completed and should not be taxed as building lots. And he listed all of them on there. There's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 lots that shouldn't be taxed or recognized as a building lot because they're not buildable. They're still, because they don't have all the utilities there. So, and he didn't include the 2 that were along Panorama, because obviously those could be adjusted as such.
When did you purchase the lot?
I think it was about 1.5 years ago.
And did you buy them as unbuildable?
Yes. Yeah. In fact, what's interesting is about a couple months ago, we've been working, actually 3 months ago, we've been working with one of the people, I can't think of his name, that works with the ag department in the assessor's office. And we're actually going to we were even going to reduce the taxes from, as they were, because they were listing them at like valuing them at like 9,000. And so the taxes for them were like 100 and something a piece. We were even going to try to reduce that. And because I farm, that's what I do. That's my trade down here in Utah. And so we were going to actually use that as grazing land, the lots that we can't build on right now. We were going to actually change the usage as ag instead of a raw development ground until we are in a position to be able to bring utilities and pave the road. So that's why it was such a surprise to us when we got this tax. Well, actually, I called in to pay the taxes, and when I was blown away at the price increase. And so I was like, well, this is not right. And so that was last week that I went and talked to the assessor's office, and I talked to Mr. Walker, and I also talked to Austin. And I think you guys have that letter there.
Yeah,
From
we see it. Let me hear from the assessor on the history and notices and where they were sent out and when they were sent out.
Okay, yeah, so the values were changed last year to bring them up to market value based on, they've been in ag, I think, for the majority of the time, and they were putting in a non-buildable, undeveloped neighborhood.
They were in ag,
For decades,
but
the majority.
were they not being used as ag? No grazing or anything?
I honestly couldn't tell you. For decades, that whole hill was in, anything that wasn't in a residential home was put in ag. And then as laws changed, they were put into an undeveloped. And based on, it's kind of challenging up in Panorama Hills, there's also Altura Verde subdivision. The permits up there are a little different. Generally, in a platted subdivision, you're going to have a developer go in and plat the division, put all the improvements in, and then begin building on them. Up on the hill there, they generally don't. We've had constant conversations with planning and zoning because they will issue a permit, and we have emails. They will issue a permit once those improvements, or once they've basically gotten word from the water district that they will allow that improvement to be put on the property. Generally, those improvements aren't put on a lot and then built on. Like, there's not improvements on every lot up there like a typical division, but they will sell knowing that improvement, those utilities will need to be put into the lot. Planning and zoning generally will not issue a permit until they have word from the water district that they can put that utility on the lot. So we've gone through, and not just in these lots, but in all of the lots up on that hill, they're brought up to market value from that developers value, basically, until we hear back. And we've gone back and forth. We've talked to Suzanne from planning and zoning. There's been no indication at all that they were not buildable. That's why all the values up there were put up at a market value. The notice was sent to the only mailing address that we have on record for P&S. It was, I believe it was an address on Deborah. I may be wrong, but it was the only mailing address that we've had. It's the same address that the tax notice has gone to. But we never heard anything back that would indicate that the property owner, at that point, there was no indication that they weren't buildable. So that's where the value remains. At this point, we do have this from Austin. We can remove the value or put those back into a non-buildable value for 2023, but the deadline has long surpassed. The conversation that he's referencing in regards to our agriculture appraiser, that conversation didn't even happen until August. So we heard nothing from the property owner beyond the appeals time, and that's why we don't have an ability to change value for 2022. Obviously, with this letter from Austin, we can remove or at least place these lots that he's indicated at a non-buildable lot for 2023. But we had nothing prior from anybody in planning and zoning. And in fact, the conversations that we had planning and zoning indicated that there was nothing to indicate that they wouldn't build on them unless they had a letter from the water department saying that they wouldn't, or from the Panorama Hills Water Company, President Van Sandefers, who we generally get those emails through. And we've had nothing. We've never heard from the property owner indicating that they weren't buildable. again, if we had, we would have removed the value at that time. And we have now, and we can remove that value for 2023, but at this point, the 2022 values are long surpassed. I mean,
It appears to me, based on this letter, that, you know, we can, have you go ahead and put those back. I do have a little concern about a conversation he had with, I'm not sure if it was Brian Cook or, you know, to move those back to ag.
yeah, so
That would concern me in that situation.
in my impression that I got, I haven't spoken to our ag appraiser, but talking to Mr. Steele, the indication that I got was that they were intending to fence it and use it as grazing. If it is actively devoted to agriculture and meets those requirements.
It's 5 acres, right? Or
Contiguous, it would be over 5 acres. So as long as it is being actively devoted to ag, we, again, and that would be an ability that we had moving forward, you know, if they went to that trouble to fence it off and use it actively devoted to agriculture, we could put it in an ag value rather than in a non-buildable value. But again, that has not occurred, that hasn't taken place, and until it has, we can't adjust the value to such. The value currently reflects as it currently sits as a buildable lot.
well, I guess I wouldn't have a concern if it was actively used as ag.
Agreed,
If it
yeah.
was fenced
That would be
and
right.
it did have livestock.
Correct.
Are you familiar with that, what he's talking about, Daniel? If you do move it to ag, you've got to fence it and actually have cows in there.
Yeah, we've actually started building the fence, and the fence is almost complete.
I think the question really just comes down to. We don't have the ability to change the value for 2022 in the assessor's office. It would require a tax cancellation. Those values have gone out. They've been certified. The taxing districts are. I mean, at this point, it's months and months late. Again, these are all adjustments, whether it's a non-buildable or an ag. These adjustments can take place for 2023. But the ability to change these values for 2022 has surpassed.
Yeah, the difficult thing we have, Daniel, is we collect the monies for all of the other taxing districts. And I think the bigger one out there is the school district, even bigger than the county. So the money goes to them. We have no way to recover. And that's why the legislature put deadlines in when we had to file these appeal. We generally get a handful of these every time this year that says, oh, you know, we just didn't notice it on our assessment. You know, but that's the obligation of the taxpayer, unfortunately, and especially somebody who's in the land development, you know, should be a little more familiar with that. So my feelings, I'm not sure there's much we can do except move forward so that you understand if you want to get the ag exemption. We're aware of, you know, and I don't know who you bought those lots from, but we had quite a deal about a year ago with them because they had built the roads and then had to come in and redo them to bring them up to standard. I don't know if you're aware of that on the road that leads into there, that you have to build the roads up to the county standard.
Yeah, no, we're aware of that, and that's and I guess that's what we're asking is we're asking for a tax cancellation, right? And from what I understand, you as commissioners, you have that power to do that. Is that correct?
It's correct, as long as it's not the situation that you're in where you didn't file the appeal. Or, you know, what we look for is like mailing the assessment notice to the wrong address. And this
Right,
and
I'm not disputing that was not sent out. I didn't receive it, but I live in Utah, right? What I'm trying to express, this is my point of view, right? And I believe that my point of view is somewhat weighted in the sense that obviously I have I'm motivated in my opinion, right? Because, and if the tax value had not gone up crazy high, I mean, when I was talking with the assessor about the values of that land, I think when it first was I think we looked back like 10 years that it was like raw ground and it was valued at like $35. Then it went up to like, eventually over the years, 50 years, it was at $9,000 from 50 years of history, from starting at $35 to 9,000. And in 1 year, Commissioner, 1 year, it went from 9,000 to 51,000. Right. And so that's a huge increase. And had I have known about what had happened, I for sure would have been in there. And that's why I drove up there last week, is because I didn't know that this had taken place. Right. We had been trying to work with the assessor's office to even reduce the value of what it was at, so that we didn't have to pay as much as it was, because we weren't planning or had the ability to get those lots up to where they're buildable and sellable, so where somebody could get a building permit, because they have to have a paved road, and paved roads are very expensive, right? So to have our tax bill go from less than $1,000 to over $6,000 is a huge increase, right, for us. And so we didn't want that to happen. And that's why I look at this as, had planning and zoning and the assessor's office had better communication on what was going on. And I don't know how that works out between them. It sounds like this is not the first time that issues like this have come up, but those lots should never have been utilized or seen as a building lot, because they can't be built on. And honestly, when I went to go talk to Austin, I said, Austin, if the county wants to view these as buildable lots, I am fine with that. And I will pay the taxes, but then you have to let me have a building permit on, and maybe we'll just put a gravelled road in. And he says, well, no, absolutely not, because we got to have a paved road. And so I was kind of, and I spoke with Commissioner Walker about this a little bit, where it's like, I'm fine with paying the extra taxes, but those taxes are viewing those lots as a building lot. And so if I'm going to pay that tax as a tax paying citizen, right, then I should be paying, if I'm paying that tax and that value is seen as such, then for this year, then those are buildable lots, right? If they're not buildable lots, then we look at this as, well, there was an error in the system, right? And that's why we have commissioners. That's why we have people like you to make decisions when things didn't go right. And I understand that money has not been allotted, but the tax deadline is not until the 20th of December. So I know that the assessment and what money is going to be sent out can change, right? But the commissioners have the power to make a tax cancellation, or to at least say, look, let's just go back to what the tax was the year prior.
Let me correct you on a couple things. Yeah, the taxes aren't due, but they're collected a year in arrears. So you're paying taxes, we collect them at the end of the year for the prior year. So the school districts have already set their budgets, we've approved their levies to collect that, and there's no way for us to go back and claw that back from the school districts. That's why they set the deadlines. And it's as hard as this may sound, the obligation is on the taxpayer to take a look at that notice and see what the values are.
I would say if we had received this letter from Austin in June and failed to make those corrections, that would be a mistake that we had made, and we could do a tax cancellation. But there was absolutely no indication at that time. I mean, there was absolutely no indication that these were non-buildable from planning and zoning until November 29. I mean,
well, and I guess I don't understand the law, but where does the burden of tax lie? Because I mean, I can go. I mean, I've got a brother that's licensed as an attorney in Idaho. I can ask him, but I don't know how tax law indicates the burden. But from the way that I understand it is that tax, legally, constitutionally, tax is an exception to law. And so when you are requiring tax from a citizen who owns property in a county, you're asking for an exception, right? And so these laws are written in such to protect the person that has to pay the taxes, which is me, right? And so, and I don't know all the ins and outs on how that law indicates that, but I do, and I get that legislators have made deadlines to keep a system in place, but that's why we have commissioners, that's why we have legislators, that's why we have people that can make decisions, so that when something fails to make sense, right, for the taxpayer, then we can make amendments to that, right? And that's what I'm asking today. And I understand that I get to ask that, and then you guys take a vote. And whether you decide to vote in favor of what we're asking is something that we could take in terms and say, well, maybe we need somebody that can judiciously take a look at this and say, hey, this isn't right, right? Because I don't feel obligated, and I don't feel it's right for me to pay tax on lots that are not building lots and assessed as building lots, right? I mean, to me, it doesn't feel right. So if you want to make that decision, that's fine, but I just want you to know that I don't feel good about that. It doesn't sit right with me. It doesn't make sense. And I understand that had you had that letter before you made those deadlines and had those assessments made, that this would have never happened, right? But that's why we have commissioners. That's why we have a means to where I can present the way that I position this, right? And we can make a decision. And that's why I'm here, right? That's why I spent time out of my day to make.
We appreciate your argument, but the one extra step you didn't point out is we have laws, and commissioners swear to uphold those laws. So you talk about having it judicially reviewed. We're going to look at the plain reading of the statute.
Well, what's the statute?
The statute says you have a deadline to file your appeal if you disagree with that value. And you've admitted that you haven't done that. We go back over the same arguments again, but
so has there never been a case in Idaho where there's been a tax cancellation?
There has, but it would have been something like the mailing address wrong. We've denied dozens of these in my time here because they didn't meet the deadline to appeal. So we would be making an exception to that. I don't ever recall one that we've denied that they have an appeal, or one that we've given a cancellation that they didn't appeal on, unless there was a mistake like we're talking about. They sent it to the wrong address, and you or your dad was denied the right to review that and appeal it. You had your appeal time. The deadline passed. Anyway, we can probably do as you suggest and take a vote. And
well, I guess I need a little more clarification, because it appears that there was some error possibly in planning and zoning. And I also am a little unclear. We haven't collected those, and so we wouldn't be clawing money back from the school district. We would just be sending them less than we committed. Are we bound to send that amount?
we're bound to send the amount that we approved their levy for.
We are.
Yes, because once they set their budgets based on our valuations, which are determined in January or June, that's how we set the valuations, and then they set their levy to correct it. If that would have been adjusted in June, they would have adjusted their levy to collect it.
So I'm learning a little bit on this then, because I assume that we just sent, what we collected, but we send what we certified to them that we will collect.
Yeah. And what this request is to change that certified amount and send them less.
So that changes my opinion a little bit, Daniel, because that then puts the burden on all the county taxpayers, to make up that difference that we will have to send to the school district,
Well,
because of a failure on your part to meet a deadline.
we can't make it up with the other taxpayers, is the problem, because their levy and their budgets have been approved.
Well, we make it up out of county reserves. I mean,
Yeah.
the county ends up eating the money.
Yeah, which comes out of what we've levied for to provide our services.
Yeah.
So, it's a difficult situation, and, you know, I sympathize with that, but, you know, the assessor's office is not typically, I mean, the building department is not typically a part of the assessor's office. You know, the building department, the assessor's office is, the assessor is a separate constitutional officer that does his job according to the statute. We review those as commissioners, you know, and I've already given you the things that we review. So anyway, I don't know what do you.
So I guess, my question is, how did these get moved from ag to non-ag to buildable?
So-
What's the process for that?
So I guess I'm running into the assumption, I can't look back for since 1974, but my assumption is that they were an ag, that whole hill until I don't know when the law was written to give a developer's discount. And when they went into that undeveloped developer's value.
It's been about 10 years ago, because I remember when they changed the law.
So when I believe at that point, they probably went from that ag land to that undeveloped developer value. And then we've actually gone through, again, this is a unique area, Panorama Hills, Alta Verde, and that the utilities aren't on every lot like they would be in a typical subdivision when a developer goes in and puts all the utility in and then they begin construction of those homes. Every home, it's not just these owned by Mr. Steele, every lot on the hill, because we've had these kind of conversations back and forth with planning and zoning on whether or not they would issue a permit. We put them all up at market value, because they are building, they are selling up on the hill now, and there is construction going on. And we have heard, this isn't the first instance that we've had somebody come in and say, I can't build on that. Again, we have emails back and forth with planning and zoning in individual instances, and they do handle these lots up on that hill in an individual instance. You know, they will look at a lot, even if it doesn't have utilities, and say, if you can provide us with a letter that says that they will grant utility to that lot, we will issue a permit.
Which isn't an accommodation by the planning and zoning,
Right.
you know, what they typically will do. Otherwise, the requirement would be to put it all under the developer. You know, that's planning and zoning trying to work with the developer.
Yeah, so that was the assessor's office placed, the appraiser placed the value at full market value based on sales and without an indication that they're non-buildable. Again, if we had heard, if we had something indicating from planning and zoning back in June that said, hey, this or these particular lots are non-buildable, as long as we have something from planning and zoning saying, hey, we will not issue a permit on that lot, then we can adjust it. But up until November 29th, we had absolutely no indication that they weren't buildable. And again, we have had conversations with planning and zoning regarding those lots up on that hill. And based on those conversations, we placed them at value because they will issue permits generally on lots without utilities.
Well, I think it's time we.
Yeah, and maybe what I do, because I don't understand the statute, the commissioners, has there been a time where you've done a tax cancellation while you've been in office?
Yeah, generally those are if they didn't receive the notice, because we have had times when.
Because I never received a notice.
Well, you said you're partners with your dad, and if his address is on Deborah, it was mailed.
Well, and his address is the one that the assessor had shown that he's got on file. Of course, he built two lots next. He built a home and then sold it and then moved just in the backyard of his other home and lives there. And I can't remember which address it's on file, but he should have got mail from either one of those. But he doesn't remember. And if he did get it, he doesn't have record of it. He does remember getting, because he had other lots that he personally owns up there that he got a notice for. And so I don't know, but I never received a notice. And so I don't, can the assessor's office have more than two addresses on file when they send out notices?
You're sent the notice as an entity, and apparently it's a partnership.
It's owned by P&S Development. I don't recall the exact address, but it was one that seemed familiar to Mr. Steele.
think you're frozen up again.
Try shutting your camera off. See if we can harvest some bandwidth for your audio.
So the question, can the assessor have multiple addresses on file when they send notices?
No, there's only one mailing address per property. And it would have been that P&S Development, and the mailing address for P&S Development that we have on file was, I believe it's on, I don't recall, I don't want to say the address, but it was the address that we mentioned and that you seem familiar with.
Yeah, the assessors can't determine who all the partners are on every entity and make sure they individually get a notice. There's usually a responsible party that they send these to, so. Anyway, what do we want to do?
I'll be willing to make a motion. I was leaning the other way, honestly, until I learned all the facts and understood the law a little bit better. And I feel like we have to protect the county, which is all the county taxpayers, just as much as we have to protect an individual taxpayer. If there was harm to that individual taxpayer due to a mistake by the county, then we should protect them on that. In this situation, I think it was failure to meet a deadline by the individual taxpayer. Therefore, I'd make a motion that we uphold the findings as is and deny the exception in this case.
Do we have a second?
Yes.
Okay. And I would have seconded it if you hadn't, so all in favor?
Aye.
Aye. Okay, I know you're probably not happy with that decision, but unfortunately, we have to administer the laws as we see that they're written, so.
Daniel, if I could, just perhaps by way of explanation for why I feel the way I do. Generally in the county, in the school district, Bonneville County's portion of the taxes on your tax bill adds up to about a third. With another third going to the school district and the other third going to the fire district and the cemetery district and everybody else out there, ambulance district. The only portion of that we could, I think, legally give back would be the county's third, which would then put a greater burden on the rest of the county to make up for that. And ultimately, this goes back to you're not filing the request by the deadline, which had you done, we wouldn't be here. The school districts and all of the other taxing districts rely on the process that's in Idaho statute. For setting their budgets and for operating within those budgets, as we do as commissioners for Bonneville County. 85% of our budget goes to the sheriff's office. So we're and their budget's set as well. So that's the reason there's deadlines. And without an error in the information process, I certainly haven't seen in the 2 years I've been here a decision that would be in favor of the taxpayer unless that error occurred with the postal service, which it did a number of times during COVID, or with the assessor's office itself, which I don't know that I've ever seen. Which means you're better than the postal service.
Okay. Well, thank you, Daniel.
Sorry, we couldn't do more.
Thank you. We'll see you.